Hello and welcome, fellow lifelong learners. Thanks for joining me for One More Thing, a radio show all about cultivating our most valuable asset, our mind, and fostering a sense of curiosity to learn one more thing. We feature passionate practitioners and seasoned experts in numerous areas of interest for lifelong learners of all ages. One More Thing is sponsored by Kiffin & Company, a corporate learning and talent development consulting firm, and I'm your host, Kiffin McCoy Albert, a certified professional in talent development, learning advocate, and your fellow lifelong learner. Welcome to the show. My undergraduate degree is in psychology and social work. When I went to law school, my plan was to use my degree to become a juvenile court advocate because I wanted to help those who could not help themselves, especially youth. I left law school after 1 year feeling lost because so many of my classmates were pursuing law with the intention of joining a big firm and making a high salary. I knew that the area of law I wanted to pursue would never be lucrative. I wish I had known about the guardian ad litem opportunity back then. It's not exactly the same as what I intended to do, but perhaps I would have been able to see it as another avenue of service. If you don't know what a guardian ad litem is or what they do, then stick around for my conversation with someone who certainly does. I'll be right back to talk with an experienced professional who is going to teach us all more about what it means to be a guardian ad litem.
Maximize impact with tailored solutions by partnering with Kiffin & Company. Developing your team is an investment, but it doesn't have to be just an expense. Discover more at kiffinandcompany.com and start your journey to effective learning today.
Aronne McCoy is a domestic mediator and guardian ad litem with a law firm in Bloomington, Indiana. While she is not a lawyer and cannot give you legal advice, she enjoys sharing her experience and knowledge gained from 7 years working within the field of law. Aronne has a master's degree in international studies from Indiana University, and during graduate school, she helped found a sliding scale nonprofit legal service, which started her journey learning how to navigate the often murky waters of our justice system. Trained by Kids Voice Indiana as a guardian ad litem and by Kim Van Valer, ADR, as a domestic relations mediator in the state of Indiana, Aronne is delighted to help spread more access and understanding about how these areas of the law work and the importance of their roles. Aronne, thank you so much for joining us today.
Oh, thank you for having me. I'm really excited.
When we first started talking about doing this episode, one of the things that I said to you is, I know what guardian ad litem is in a very, very basic way, but I don't know a lot about it. But I'm sure that there's a lot of people that maybe they've never even heard of it. They don't even know what it means. So how about we start with you just telling us, like, what does guardian ad litem mean?
Yeah, absolutely. I run into tons of people who have no idea what that is. I've never even heard of it. So a guardian ad litem is a court-appointed individual who represents a child's best interests. They have them in every state, as far as I'm aware. But in Indiana, because I am not a licensed attorney, I only handle civil cases. So you can be a licensed attorney, a licensed mental health care worker, like a social worker or a therapist. You can volunteer and go through the training. I went through the training. So I'm sorry, that makes it sound like not everybody has to go through training. Everyone has to get trained to be a guardian ad litem, but the training is usually at least 12 hours. We've actually just for 2025, in January 2025, the state of Indiana has started some new laws and guidelines because the field of guardian ad litem work it has very little oversight. And if you get a good guardian ad litem like me, who really cares and has their own ethics that they're really living by, and really wants to help children, then you've gotten a great guardian ad litem, and that's wonderful. I've heard a lot of stories from people that they've had a guardian ad litem who they felt was really dismissive, or who didn't actually meet the children, which is a huge no-no. They did things that I know from my training are not ethical or violate the agreement that we make when we become guardian ad litems. So if anybody's had a negative experience, please don't hold it against all guardian ad litems. Some of us are really good and really care.
So let me back up just a second. So one thing that you said is that everyone has to get trained, but if I understood you correctly, there are avenues. So a lot of guardian ad litems might have a social work or licensed counselor, those types of already in that kind of field of social service. But then folks who don't have that background can still go through a training to then be, is it certified?
It's registered.
Okay.
So yes, there is a training. So I did mine, as you mentioned earlier, through Kids Voice. They're in Indianapolis. They are a really lovely organization. I read a lot about them before I signed up to do the training with them. I really appreciated their mission, their desire to be a voice for children. My training was longer than 12 hours. The 12-hour rule is the one that they're going to be really strict about starting in 2025. The state of Indiana is working really hard to really sort of unify and give people a really clear path. What you want to do is advocate for children.
In like super layman's terms, what does guardian ad litem mean?
It literally means appointed by the court. Ad litem is usually what trips people up, but it is a literal appointment from the court to speak for a child. So in court proceedings, we don't have children typically take the stand, for example. In situations where a guardian ad litem is called for, you're usually trying to find out what is going to be the best situation for this child. The best interest of the child is always the foundational tenet for everything that you're doing. How can we provide the best possible environment for this child? Unfortunately, sometimes it is choosing between a parent who is an addict and in and out of rehabs or alcohol programs or whatever, and a parent who has pending charges. So it's not always very clear who is going to be the best possible support system for this child, but that's what we're aiming for, is to make sure that we are supporting a kid. I am so sorry. I think my ADHD is so bad today. I've lost the thread of your question. What was your question again?
Well, the main thing that I was asking is just like literally, what does it mean for a guardian ad litem to get involved in a case? Is it because a parent wants it? Because another family member wants it? Is it because the court, a judge or prosecutor or I don't know, like says it? So you made the statement about it being appointed. So is every guardian ad litem situation one where the court has appointed someone to be a part of the case, or are there cases where like a parent maybe asks for it or something like that? Like, how does that work?
Okay, yes, I see. So a judge can appoint a guardian ad litem for a variety of circumstances: allegations of child abuse, neglect, endangerment, anything like that, a request from either or both of the parties in a case. So usually it would be like mother and father, maybe grandparents and a biological parent, something like that. So either of them can request one. The child can request a guardian ad litem. I have not run into a whole lot of children who know what a guardian ad litem is, but especially I think for older children, it's nice that they're allowed to request that. It can also come as a recommendation from mental health care professionals, any kind of like custody evaluator or parenting coordinator. And then a judge can also appoint on their own decision if they feel like either parent or party is not adequately representing the child's interests. So if the child doesn't have anybody who's advocating for them, I think a lot of parents feel like they are doing that, but the language they use does not get that across. So what we hear most often is, well, I want to have them for Christmas because Christmas is really important in our household and other parent doesn't care as much about Christmas. That's about what they want. It's not about what's the best interest of the child. That's about the parents. And I hear that a lot, that kind of stuff a lot from parents. I want, or this is what I think should happen. And they forget that it's not about what the adults want. It's always supposed to be about what is in the best interest of the child. It's really difficult sometimes to keep parents focused on best interest of the child. What you want for custody is not necessarily what the child wants or even what is in the best interest of the child. And I do want to add a little caveat onto that. Guardian ad litems and judges too, pretty much anybody who's involved in the court system, we understand that if you ask a 6-year-old, are you happier at mom's house or at dad's house, which is actually not a question I would ever ask of a child. But if you ask them something like that, they're going to tell you whichever parent, lets them have chocolate cake for breakfast or gives them unlimited screen time or, maybe doesn't pay as much attention to them in the afternoon so they can do whatever they want. We don't solely rely on what a kid says they want. But I think it is important to listen to kids. and to let them feel heard, to make them feel like they are important, that they are of value, being able to tell them, I'm here for you. You tell me, what do you need? What do you think? The change in kids' faces when you just acknowledge that that's a person. I think a lot of people tend to think of children as like an extension of themselves or an extension of their parents, but they are very much their own people, and they are way more aware of the things that go on in their home than I think most adults realize.
Part of your job as a guardian ad litem is to evaluate both homes and both situations, because like you said, that if you ask a child, they may say that whichever parent is the most lenient or whatever. But I also, just in my own experience with people, is that the child might also choose whichever parent either they feel guilty not choosing, or whichever parent they think needs them. Yes. Which is also not the healthiest, right? So one, I guess, big piece or big point that we want to make is that a part of the role of the guardian ad litem is to evaluate both situations or all situations to determine, like you said, the one that's the best for the child, not the best for any given parent.
Yes, I worry sometimes that people will go into a situation as an observer or an evaluator with their mind already made up because of their personal experience or because of some small incident, a thing that a parent said or the way that they shut the car door, like these really tiny details. It is my job to set aside all of my own issues. That was a big thing I learned in grad school, because my grad school experience was very science based, like having to do statistics and learning how to do things in a way that it's not that you are ignoring your personal hangups or prejudices or whatever. You have to actually pull those things into the light and look at them and acknowledge them, which is horribly uncomfortable, I think, for most people. And you have to understand that they're there before you can give a fair evaluation of anybody else. So having to, really like look at that and acknowledge like you have this prejudice about this is so important before you ever step into anybody else's home to judge them. I have sort of a little like speech kind of a thing I do for all my parents. The very first thing, it's sort of a joke in our industry, is I am not a lawyer. I am not your lawyer, and I cannot give you legal advice, because people don't understand some of the really finer points of the law. And so it's a question they have. Why can't they ask me? I clearly know, but I'm not allowed to cross that line into giving legal advice. And there is a very strict standard and definition of what that is. So I have to be very careful not to cross that line. Sorry, I feel like I've been talking forever. Do I need to shut up so you can ask anything?
No. I mean, this is good because you're sharing, you've got a lot of knowledge around this and you're sharing that, which is the goal, being a lifelong learning show. This was a topic that I thought people might be interested in because they may have heard of guardian ad litem, but really not known about it. Yeah. So let me go on though and say that, okay, so we've talked about like what it is, that it's an appointed advocate for the child in civil, in your case, specifically civil cases. You have talked a lot about what's going on in Indiana where you are. Mm-hmm. I'm assuming that within other states, that state specific, there are different aspects of this world, but is it, as far as you're aware, is it something that's fairly standard throughout the United States?
I don't have a whole lot of experience or knowledge about other states and the rules and stuff around them. Just to make sure to clarify a point, you always had to have training to be a guardian ad litem in the state of Indiana. It's just that the rules that are coming in 2025 are trying to lay out a very specific standard that all of the trainers have to adhere to, so that they know every guardian ad litem in the state of Indiana has had at least this training.
Hey, as a training professional, I love to hear that, because the lack of consistency and the all over the boardness of so much, oh my gosh, we would all do ourselves a favor if we could get together in industry, or, I mean, my God, even across departments in one organization, and have some consistency of experience for, and it makes me think about onboarding, for example. But do you know of things that are consistent from a guardian ad litem standpoint across the US, or just strictly the use of it?
The foundational tenet is always what is in the best interest of the child, which is actually, I think, really helpful, because you have to make some really difficult calls sometimes. And I always just go back to that. And that seems to be really good at helping me forge a path of how am I going to help this kid? Like what is in their best interest? Even like having to deal with the parents. Parents can push your buttons. They're people. They're human. You're seeing them at not a great time, maybe even the worst time in their life. They're not always going to be polite and kind. So you have to just know that going in. Having that always almost like a mantra in the back of your head. Best interest of the child. Is it in the best interest of the child for you to get into some kind of altercation with their parent who could then say, I don't want a guardian ad litem? No, of course not. So that makes it a little bit easier. I would imagine that's true across all the states. I know that is the foundational tenet. And so I would imagine many guardian ad litems, regardless of state, keep going back to that and find help in that and guidance in that. Outside of that, I would assume they all have to file written reports. That's part of my job. But other than that, no, I really don't know of any for sure across every state. This is true.
Yeah. Well, it makes sense that that all the particular rules and regulations and stuff are going to be state specific, although it would certainly be nice for states to get together and kind of come up with some foundational things. You mentioned about the reports. So we're going to take a quick break, and when we come back, the two things that I want to cover, one is around so what you have to do and how the judge or the courts use that. Yeah. And then if you have any stories that you can share. I know you can't obviously give any specifics and certainly not names, but some examples of how you've been able to impact families. So we'll be right back after this short break and talk to Aronne a little bit more. Facing legal challenges can be overwhelming, but you don't have to go through it alone. At Sutton Law, we provide compassionate and practical legal solutions tailored to your unique needs. Whether you're dealing with family law issues, small claims disputes, or criminal defense matters, our experienced team is here to guide you every step of the way. Led by founding partner Jamie Sutton, a dedicated attorney with extensive experience in criminal defense and family law, our firm is committed to achieving the best possible outcomes for our clients. With offices in Bloomington and Bloomfield, Indiana, Sutton Law is ready to assist you. Contact us today at 812-269-2641 or visit jsuttonlaw.com to schedule your consultation. Sutton Law, compassionate and practical legal solutions. All right, welcome back. Thank you so much. And we're talking with Aronne McCoy, who is a domestic mediator and a guardian ad litem in the state of Indiana. And Aronne, thanks for being on the show. And as we are coming back from break and we're getting close to the end of our time together, I wanted to ask you, what is it? So we know that you evaluate situations, and you mentioned earlier that you have to write a report. So I'd love for you to share kind of what you have to do from that write-up perspective, and then how does the court system or the judge use what you have written up?
Guardian ad litems are responsible for researching, examining, advocating, facilitating, monitoring the child's situation, which is a lot. We also have to prepare a report that gets filed with the court. It is required by law to be submitted 10 days before the court date. I am also required to testify about my findings in the report in court. I call witnesses if necessary. I also am the one who would refer a child to professionals for diagnosis. So for example, if I was getting a strong feeling that a child maybe had ADHD, I would recommend that they be screened for that or evaluated for that. And then I often will continue to supervise after a custody order has been entered to make sure there aren't going to be any other problems that crop up. That's kind of an indefinite period of time. It's really just sort of case by case. So it depends on how long. But when I'm ready to exit, I just file a thing with the court that says, I'm withdrawing because I'm not needed anymore. In terms of the report itself, one of the reasons I think that the 2025 guidelines are coming in for Indiana is because guardian ad litems have almost unfettered access to all of the personal information that we've worked really hard as a society to try and protect. So for example, I'm allowed to look at medical records. I can speak to the child's teacher, see their report cards, counselor, any of that kind of stuff. Parents are required to give me the information that I'm asking for. I am very thorough as a guardian ad litem. I'd rather look through things and then say, okay, I don't need that. Parents send me evidence, is what we call it. Text messages, screenshots, emails, pictures. If parent A is alleging that parent B was physically aggressive with them, during a pickup or drop off and they took video, I review that video. So I review all of the information that impacts the child in this case. And then I report that in writing to the court. The reason that they do that is because a judge does not have the resources to really investigate in a situation. Parent A is saying parent B is abusive and using drugs. Parent B is saying, no, I'm not doing that. Parent A is. The judge doesn't know. You're sitting in a courtroom, probably dressed in nicer clothes, on your best behavior. And that's what the judge is seeing. So she doesn't know, which parent is telling the truth, which one is lying. If there is anybody lying, for that matter, it's very difficult in those short court sessions for a judge to determine what's going to be in the best interest of the child. That's why they appoint a guardian ad litem. So that's why I get called in by a judge usually. I do the investigation. I look at everything in the child's life, extracurriculars, even like if there's an issue with friends, I will talk to the friends, classmates, whatever. And then I write my report. I try to remain completely neutral and fact-based. So I would say things like parent A has reported they believe parent B to be using drugs in the home. I do not say this person is. I can require somebody to take a drug test. So if I show up with I can't make them, but I can report that they refused. So I generally have a pretty good, clear understanding of what's happening in the home and with the child. And then at the end of my report, after I state sort of the facts, I make my recommendations. I almost always request that the family do therapy, unless it's just like they can't come to an agreement about custody or something. There's almost always trauma for the child. People still have a lot of stigma attached to mental health care, even in 2024. I run into it a lot. I hear parents say things like, kids don't need therapy. And it's just untrue. It's just blatantly untrue. And getting children the therapeutic help and care that they need now prevents them from going through some pretty horrific struggles as an adult. So I do recommend that a lot. I can make recommendations about the parents getting therapy or drug and alcohol help or anger management help. I have recommended anger management classes before. I really can recommend just about anything.
In your experience, I'm sure people have had different experiences with different judges and all, but in your area, in your experience, do the courts usually take your recommendations and go with them?
The short answer is yes. The longer answer is judges are busy. I mean, there's still kind of some recovery happening from the after effects of the pandemic. They're in court all day, every day, back to back to back to back. Not only do they not have the time to adequately investigate every individual situation that comes before them in court, they don't necessarily have the training to go in and make these calls. So I think that they rely pretty heavily on us to do our jobs, to have gotten the correct training. We are required to do CLEs, which is like continued learning credits. We have to do 6 hours annually of that. So they are trusting us. They are depending on us to make sure that we are following to the letter of the law our job requirements. And so I take that very seriously.
We are almost out of time, and I really, really would love if you have one to share a quick story of like maybe a quick success story of a situation to where you were able to make a positive impact as a guardian ad litem.
The thing that pops instantly to my mind, I need to be very careful about the details I give. So if I don't tell you something, it's because I shouldn't. I had a mother who I have been called in as guardian ad litem because mother wanted to get her parenting time back. She had lost it due to drug issues. Father was very reluctant about allowing mother to have more time. I think because I had no judgment about having had drug issues. Addiction is a disease. We don't always treat it that way in our society, but it absolutely is. And I think when mother saw that that was my attitude towards her, that I recognized she was suffering from a disease and was trying so hard to overcome it, I was able to alleviate many of father's concerns because I went in her home. And I checked and I looked. There weren't bugs. There wasn't drug paraphernalia. There was food in the fridge. There was space for the child. The child had a bed and playroom set aside for them. Being able to be that bridge between two parents who are struggling to co-parent appropriately because of things that had happened in the past. And they weren't necessarily irrational issues, but they couldn't see a way past that for either of them. So being able to bridge that gap and bring these two parents together where now they co-parent beautifully. No problems. It's been one of the things that I think about sometimes when I'm having a really difficult case or a really hard time or something. I think about that and remember that that's why I'm doing it. That I really am trying to help people become the best co-parents they can possibly be.
What a great way to wrap up about the guardian ad litem
Yeah.
process and all. Like, that's awesome. Very good to hear, and hopefully maybe gives some hope to even some of our listeners that are struggling. Well, I always end every show asking my guest, what is something, this is a lifelong learning show. So what is something that you are learning about these days?
Oh my gosh, there's so much. I guess the thing that is like most in the forefront right now is Indiana University, where Kinsey Institute is. If you don't know about the Kinsey Institute, please, for the love of all that is holy, go and look it up. They do incredible work. So I am actually thinking about trying to get a certification through the Kinsey Institute in human sexuality. They are an incredible organization. Please go donate, go see their exhibits. They're incredible.
Okay, awesome. So a little bit more on the formal side of learning right now. You've got another certification in mind.
Actually, you know what? Yes. But one of my favorite things about myself is that anytime during the day I come across something that I don't know, a word I don't know, or something like I remember the first time I heard about fracking and I was like, what? What is fracking? I immediately stop. Or if I can't, I'll write it down. And then whenever I can during my day, I will go and research it.
Awesome. Well, so you're an advocate for lifelong learning. I
Oh,
appreciate that.
yes. Yes. Please learn all the time.
Well, thank you again so much for being here today and sharing some of your knowledge and expertise. I hope that our listeners will take time to look up a little bit more about the guardian ad litem system in their own state, and maybe even you'll inspire someone to volunteer and become, which I do want to make sure to say two things. One is I want to reiterate that this was not legal advice, that this is Erin's particular experience, but also I think we've said volunteer a couple of times, but I want to make sure people understand that guardian ad litems are a paid position, correct? This is paid through the court system. Obviously the pay is going to be dependent on your area. But anyway, maybe you'll inspire someone to become a guardian ad litem and have that thorough and compassionate heart in that service.
Yes, it is very rewarding. I do recommend it as long as you have strong grasp on your emotional and mental health. And thanks for inviting me.
Well, that was another great conversation with many ideas relevant to workplace learning. But as usual, I'll keep this short and just pick one. Aronne told us about the foundational tenet of being a guardian ad litem, and that is to always focus on what is best for the child. As a learning and development professional, I think it's important to remember that we should design and execute based on what is best for the learners, which is our workforce. I realize that we need to provide training to meet our organization's business needs, and having outcomes-based approach is vital. However, we need to take that next step to ensure that the methodology and the strategy for reaching those outcomes keeps the learners in mind. Don't make reaching those outcomes harder than they need to be. Thank you again to my guest, Aronne McCoy, to our episode sponsor, Sutton Law, and as always, thank you for tuning in week after week. You've been listening to One More Thing, a radio show on the Power Me Up radio station on iHeartRadio. I'm your host, Kiffin McCoy Albert. Thank you so much for listening, and I look forward to you tuning in next time as we continue cultivating your mind with one more thing.
If I recommend something, I assume that a judge is going to say yes to that. So I'm very careful about making recommendations. My attorney can tell you I will fret sometimes for hours over the exact wording of a document because I want to be very clear and not ambiguous or unfair to anybody.
In a conversation with the attorney that you're working with or through or whatever the right wording is, that you have become maybe preferred is the right word, but that there are judges who are requesting you or appointing you when you haven't even signed up, or whatever, you haven't really said that I'm available for this one, and they're like, no, we want you. If I understood that correctly, then that says to me that as judges in your area get to know your work and see that you're good at what you do and that you are keeping that what's best for the child in mind, that they are going to prefer to have you work on a case. So that's going to keep you busier and busier as you go. Is that true?
Yes, it is. To some extent, I like to think that because I'm very dedicated and I tend to go a little bit above and beyond. So just as an example of what I mean, there is a judge here in Bloomington that I have an enormous amount of respect for. I think she is the epitome of the kind of judges that I wish everybody got to see. She is extremely fair and dedicated to being a neutral judge. You're literally deciding for other people what's going to happen in their lives. I think she takes that extremely seriously. So I have an enormous amount of respect and admiration for her, both as a person and as a judge. And I have gotten several cases through her court. And I think in part it's because once it was a super shortened time period that this case needed to be completed for a variety of reasons that I won't go into. In court, she said, don't worry about having a written report. You can just give your oral testimony. Because I think I literally only had like 2 weeks to do this investigation, but I submitted a written report anyway for 2 reasons, really. The first is I felt like that was the best way for everybody, because that report gets submitted to everybody. I mean, everybody gets a copy of it, everybody involved in the case. I feel like it's the best way to make sure everybody gets the exact same message from me, that they're not hearing it secondhand, or that they're not interpreting little bits and pieces for themselves. I want them to have an understanding of why I have come to the conclusion I've come to. And I also submitted a report anyway, because I felt like the judge should have adequate resource to kind of lean on in order to make her judgment. And that's harder to do when you're just hearing somebody tell you, and then you're trying to, in your mind, think, okay, so maybe this would be better or whatever. I want her to have that hard copy of, well, okay, and you noted this here, I should keep that in mind, that kind of thing.
Right. Yeah.
That's important to me. I think when you are consistently doing things like that, just going a step above and beyond, I think people notice. And I think they recognize that that is a sign that you are very serious and that you are taking your ethical duties very seriously.